Please be advised that this recorded webinar has been edited from its original format, which may have included a product demo. To set up a live demo or to request more information, please complete the form to the right. Or if you are currently not on CSE Global, there is a link to the website in the description of this video. Thank you.
Hello everyone, and welcome to today's webinar, Doing Business Outside Your State, Foreign Qualification. My name is Annie Triboletti, and I will be your moderator. Joining us today are guest speakers Beth Lyden and Zach Beaver from Dykema, and Pat Nolan from CSC. And with that, let's welcome Beth, Zach, and Pat.
Thanks, Annie. This is Beth Lyden here. Thank you for joining us today. Let's launch into it. So, foreign corporations, the basic definitions, corporation is considered a foreign corporation if it's doing business outside of its state of incorporation. And for a foreign state, that's going to be any state other than the state of that corporation's formation. Corporations are legal entities that are created under the laws of the state of its incorporation. It exists because of the laws of its home state and is subject to regulation by its home state. So, if a corporation is properly incorporated and only conducts business within its state of incorporation, it will not be subject to regulation by other states. In practice, it's rare to limit business activities and operations to the territorial limits of your state of incorporation. And because a corporation is created under state law and is a state-created entity, it has no legal existence beyond the limits of the jurisdiction where it's created, so its domestic or home state. And a foreign state could refuse to recognize the existence of that corporation created under the laws of another state and set conditions on that corporation's activities within its borders. Most states have statutes in effect that require an entity to be qualified or registered, and you have to ask for permission in order to conduct business in another state. Typically, qualification involves obtaining a certificate of authority from the foreign state and maintaining a registered office and a registered agent, as well as complying with annual or semi-annual reporting requirements and tax liability. So motivations behind, I went too far, apologies. Because a corporation is not a natural person, the state can permit or prohibit a foreign corporation from doing business within its borders. This would be interstate commerce, and require that foreign corporations comply with certain conditions, provided that those conditions don't violate the Commerce Clause. States may not enact laws that place undue burdens on interstate commerce. There are consequences when a corporation does business outside its state of formation, and it will find itself subject to service of process and suit in that state, subject to taxation by that state, and they'll be required to qualify to do business in that state. They each involve doing business or transacting business, but there's overlap, but these are not exactly the same inquiries. So the description of doing business for purposes of foreign qualification really should focus it's a different inquiry. It's not applicable to other questions, such as whether or not it's going to be amenable to service of process under a state's long-arm statute or liable for state or local taxes. A foreign corporation that's registered or required to register will generally be subject to suit in that state or state taxation, whereas a foreign corporation that is subject to service of process or state taxation will not necessarily be required to register or qualify within that state. So for service of process and being subject to suit in a foreign state by virtue of long-arm statutes, that's a slightly different inquiry that's going to have certain contacts within that state, such that they feel at home. And taxation, states really push the boundaries of that one. Wayfair was huge because it shifted the nexus from physical presence to economic presence. And again, these are different inquiries from whether or not a foreign entity is doing business within a state, which is what we're focusing on today. So why would a state want a foreign corporation to qualify? The first motivation would be transparency. It's really important for foreign companies to disclose information about themselves to state agencies so that people know who they're interacting with. This information would be publicly shared through the application for authority, for certificate of authority, and in their annual reports. They're required to keep certain information up to date, such as sometimes like who the directors are, and they can be penalized if they fail to keep this information current and filing these annual reports. Another reason would be to facilitate service of process, because you have to maintain a registered agent and a registered office within that state. And they have to continuously maintain these. Without the registered agent requirement, you wouldn't be able to serve process as easily on these companies. You can always still serve process on a company as long as you're following the civil procedures rules. But it ensures that there's an in-state agent and location for service that's very easy to locate, just going online and checking Secretary of State filings. A third reason would be to protect domestic companies. They allow states to make foreign companies doing business in the state, make sure that there's no unfair advantage to these foreign corporations for taxes, filing annual reports, and maintaining registered agents. Those are the primary motivations for protecting domestic citizens and corporations. Added bonus is the revenue stream. And that, Zach?
All right, thanks, Beth. So I think to transition from Beth's point is we need to look at the nexus between qualification and taxes. And so in some states, qualifying will subject you to whatever the state's applicable business taxes are. For example, you have sales tax, you have income tax for employees, you have other kind of state mandated taxes that might apply, that might trigger. So generally, once you qualify to do business, there's at least a presumption that you must comply with whatever the state's taxes are for the foreign state. But just because you're required to pay taxes, it doesn't mean you're required to register to do business. So it gets kind of complicated when you start talking about other states that you're going to do business in, or other states you may have contact with. If your entity is, for example, you have a Delaware corporation or Delaware company doing business in Illinois, you may be subject to some kind of tax based on interactions you're having in the state of Illinois, but you may not be required to do business. You may not be required to register as a business in Illinois, and so and this depends on all the state. Every state's going to have their own kind of qualifications and their own analysis on how that applies, their own statutes. So it's important to look at those on a state-by-state basis. For example, one of the important cases that came out, I think 2018, was Wayfair in South Dakota, where the Supreme Court, South Dakota implemented a statute which said that they were going to tax e-commerce companies with no physical presence in the state, and try to generate revenue. Kind of the best point that's a key driver for a lot of this stuff is states trying to get their hand on money that they feel they're due. So they passed this statute to tax these e-commerce companies. It's challenged. It goes ultimately to the Supreme Court, and the Supreme Court said, kind of in a break with history, that it's fine to tax these e-commerce transactions even though there's no physical presence in the state. And so so Wayfair is not required to register as a business in South Dakota, at least to my knowledge of South Dakota law, and so they still are on the hook for taxes. And so you have to be careful when you're operating in other states, because even if you're not required to register, you may owe taxes. And even if you are required to register, it may still change the tax situation. So it's it kind of just depends on which way it flips depending on the state you're in. So another good example of this is in Alabama. There's almost, the state statute is almost silent as to whether or not you're required to pay taxes versus register as an entity. But what the Department of Revenue in Alabama has said is, if you own property, if you're a foreign company, you own property in Alabama, you have to pay, you will be subject to business tax liability. And then there's kind of this other approach that says, also, if you're registered, you're subject to these business taxes. So it kind of makes the distinction very clear, at least in the case of Alabama, that if you're registered with the Secretary of State, you have to pay taxes. But that doesn't necessarily mean if you, and I guess it kind of marries up. So what you have is this two-factor approach. You have A, if you own property, Alabama is going to tax you if you're a foreign entity. Also, if you're qualified to do business, whether or not you own property doesn't matter, they're going to tax you. And so you kind of see how the state doesn't tie to one or the other. They are trying to cast a broad net to make sure you fall within what they think they have the taxing authority over. So even if a state has jurisdiction over for tax purposes, they may decide not to exercise general jurisdiction for litigation, for court and service of process proceedings. So that's important because it kind of goes back to the last point, which is even if you're paying taxes, the states may say, we don't really want you to fall under our court systems. We don't really want you to be hailed in Alabama or whatever state, but we do want your revenue. And so it's very important to know kind of what the state landscape is before you get really involved in registering your foreign entity. And as a result of this, one of the important things you've seen is a lot of law firms will not subject to tax opinions. So if you're doing a legal opinion for any kind of deal, any kind of entity, anything like that, most law firms won't opine if it's not their state, the state they operate in, because it's too muddy. They don't want to get involved in it, and there's just a lot more at play. So you just kind of see law firms staying away from that generally. So what requires foreign qualification? When does your entity need to register with another state? The key test is whether you're doing business. And so the question is, what is doing business? Well, in a true lawyer answer, the answer is it depends. And there's 50 states. You know, you have a myriad of laws. Some have adopted the revised Model Business Corporations Act, some have not, some have taken pieces of it, some have not. So what you see is kind of all over the map as far as how states approach the way they govern foreign entities. About half the states in the U.S. have adopted the revised Model Business Corporations Act and the governing provisions. But to make things even more complicated, those provisions about doing business are generally in the negative. So it doesn't say this is doing business in the statute. It says this is not doing business in the statute. And so then it's kind of left up to courts and attorneys and businesses to figure out what is doing business. And there's some general guidelines, which I'll get into here in a minute, but it's just important to understand that most of the time it's viewed in the negative. So I think the not doing, so when you look at it in terms of not doing business, what it does is it leaves a lot of room for states to be creative and aggressive, because if you had a list of 10 things that are doing business that would subject an entity to be qualified in your state, arguably the things left off of the list are not doing business and therefore would not trigger some kind of registration requirement or foreign qualification. So by making the list in the negative, states say, well, we're going to carve out these things. These things are not doing business, these 10 things. Everything else we're not going to opine on, there's no statute on, so it kind of gets sorted out in court, and it's kind of left open for interpretation based on whatever the statutes are, or other existing statutes, or case law, or precedent, or whatever else is out there in that state. So it doesn't foreclose the state's availability to bring you in and say, no, what you're actually doing is business. So a few things that are generally considered doing business. These are not adopted by any particular state. These are just general guidelines on what we've seen as constituting doing business, and things that, that should guide you as to whether you're thinking an entity is doing business in a foreign state. So, this is very specific depending on the state involved. But generally speaking, if you have a physical location, facilities, offices, stores, warehouses, things like that, that is a factor that would cut towards you doing business in a state. Similarly, if you have employees in a state, and whether or not it's one employee or 100 employees, it does make a difference, but it's not there's no clear distinction. So if your one employee is facilitating millions of dollars in transactions, that might be a good indicator that you're doing business, even though it's only one person. So it's just important to consider kind of the weight of the involvement. Whether you regularly contract within the state, the foreign state. If you make one contract, this was a good example I've seen before. If you make one contract, you sell $200,000 worth of goods to one person, that's less likely to be viewed as doing business as if you were to do half a dozen or a dozen contracts for $200,000 with a dozen people or businesses or whoever in the state. So you kind of have this factor. So even though you have the same dollar amount on the deal, maybe having a dozen contracts affects the state more or raises that threshold to the level where the state does want to get involved. And there's no clean line on that. It kind of is fluid based on all the factors. Whether you regularly hold customer meetings is an important factor because, part of what, as Beth mentioned, part of the idea is to protect the citizens within the state. So if you're meeting with customers, you're soliciting customers in the state, you have offices, you have employees, it starts to look like you're really conducting business, and the state probably is within its rights to try to rope you in and make you qualify. And then lastly, whether there's significant revenue. And this kind of goes back to what I just said about the contracts. If you have, what is significant revenue? Well, we don't know. And maybe it's 200,000, maybe it's 100 million, but it also will depend kind of on all the other factors out there. And so, for example, like I mentioned in the Wayfair case in South Dakota, even though it dealt with taxes and not so much revenue, the state of South Dakota set a threshold of $100,000 for goods or services in the state. And so for them, that was significant enough to trigger a tax bill for the transactions. And so it may be something similar to that when it comes to revenue, that companies should look at and say, well, how much are we doing? When you look at all these kind of 5 factors, what's the weight of our involvement in the state? And really, is it going to rise to that level where we just need to qualify and make sure this is all taken care of? So a few examples, as I mentioned, most states have adopted the Model Business Corporations Act provisions for what is considered not doing business. So again, in the negative. So in Illinois, and this is from the statute. So 7 and 8 are blank because the Illinois statutes are blank, but arguably they would insert or change as they needed to. So in Illinois, maintaining, defending, settling any proceeding is not doing business. Holding meetings is not doing business. Maintaining bank accounts is not doing business. But the key important thing when you look at this list is these things individually are not doing business. But in the aggregate, they could be doing business. If you're doing all of these things, plus, anything from the previous slide of having offices, employees, or any of those things, you may be considered doing business. So while this list says this individual thing is not doing business, it's important to understand it's all viewed in the broad context and not just, well, as long as I'm just own personal property or real property, I'm fine. Well, if you own real property and you're ushering goods in and out of it and you have employees at a dock taking care of those goods, that might be a different story. And so it's important to understand these are kind of safe harbors, but it's not a complete protection as long as these are the only things on the list. Continuing with what is considered not doing business. There are some states that have public policy exceptions for doing business. So, for example, if, in Texas recently we had the ice storms which put out some of the windmills and really disrupted the power grid and the situation down there. So if utility companies were to go in, or you had vendors that dealt with the windmills or the chemicals that they sprayed to de-ice them, any of those kind of transactions, if there's a declared emergency and companies are going down there to deal with this emergency, a lot of states have sort of this public policy exception so that they're not being roped in for this one-time emergency situation. And now they have these onerous requirements to register and pay tax and do these things. And of course, like any of these other, most of the prior slides, these are state-specific, and there's not necessarily an overriding blanket of how this would apply. But as a general rule, a lot of states look at it this way because you don't want to discourage people from helping your state out in an emergency. You don't want to discourage us from helping each other and that sort of thing. So there's kind of this broad public policy exception for that. And then what you'll see sometimes, which I don't think is necessary, is kind of this foreign interstate and foreign commerce carve-out, which some states will put into their statutes, and it basically says, if this business is involved in foreign or interstate commerce, then we're not going to restrict it unnecessarily with state law, and there would be some kind of carve out or some kind of exceptions to the requirements. But I don't think that's necessary because at the end of the day, U.S. Constitution prevails. So it really doesn't matter if the states provide this carve out. You're not getting anything. Either the Constitution governs or it doesn't. And if it does, then kind of what the states say at that point, it really doesn't matter. You didn't need the carve-out if the Constitution was going to prevail anyway. So those are just a couple of other not doing business things to be aware of. They're not kind of the enumerated ones. These are just more overriding. They may be out there, so just kind of be aware of that. So again, this is kind of going back to the slide a few back where we discussed what doing business is. So you usually have to qualify in a state if you have a physical presence, if you're repeatedly engaging in transactions, if you have employees, or if you engage in intrastate commerce, meaning within the boundaries of that state. And so these may be different requirements for tax versus qualification purposes. And that's something that you really just have to be aware of on a state-by-state basis, case-by-case, whether what you're doing rises to the threshold of tax liability or other kinds of fees, or whether it requires you to register, and if qualifying requires you to also pay some taxes. So it's just kind of an interplay that you have to be aware of on a state-by-state basis. And CSC provides some really good services for that purpose. They can kind of provide you some charts and help assist you, guide you through the filings and the requirements that you'll need for each specific state. So, make sure you consult with them if you have questions about that kind of thing. They'll be able to help you with that. So one of the things I mentioned before is your activity within a state is going to be viewed cumulatively. So if your company is engaged in one sort of activity, but it's kind of minor, you may not be required to qualify. But again, if it rises to a certain threshold, you may be required to register. And so the way this is looked at from the courts is each piece is kind of weighed together with all the pieces to figure out if it's going to get there in that specific state, if you're going to be required to do certain things. And so like I said, having a sales rep may not be enough. Even some employees having warehouse goods might not be enough. But, when you look at all of these things sort of together, it may be. And so, Daryl Pierce was with the firm. He recently retired this year. And he gave this presentation last year, just a brilliant legal mind. And he had a quote from the early 1900s, and I don't know the case, but I did copy the quote because I thought it was such a good, look at how courts are going to look at these qualifications and kind of how we got to the history of kind of how we got to where we are. And so while a lot of these issues have been resolved as far as protecting citizens and taxation and some of this stuff, it still gives a good sense. So the quote is from the court in this case was, "It was a practice of many tramp, predatory, rapacious foreign corporations organized under the laws of nobody knew where to violate contracts or injure folks in our state and avoid process." So this kind of sets a tone that I think should stick with a lot of people, that when states are setting these laws and the courts are reviewing them and they're trying to decide if a company should be subject to the state's laws or qualify as a foreign entity or doing business, there's this tone of, we're not going to just let companies come in and do whatever they want. So, be aware of that. Be aware of what these companies what your company is planning to do, what they are doing, and just make sure that's square with whichever states you're operating in. So I think that quote, even though it's 115 years old, I think it sets a good tone to understand the real nexus here is to protect citizens within the states, and so that's what the states are going to do. Aside from trying to generate revenue, that's what they're going to try to do. So I think the next slide, I'm going to turn over to Beth.
Thank you. Yeah, so if you're a corporation that wants to operate in a foreign state, there are a number of motivations for not wanting to qualify. However, as Zach mentioned, there are significant public policy and interests that the foreign state would want to protect. So a lot of these motivations, there are ways of rendering them moot. So if you want to avoid certain tax or revenue requirements, true, that is a significant motivation for not wanting to qualify as a foreign corporation. However, you run the risk of not being able to avail yourself of the court systems of that foreign state, and you risk having your contracts possibly invalidated prior to you being qualified. We'll go into more details about that later. You don't want to have to comply with certain registration and compliance requirements of these other states. Again, Wayfair kind of really pushed the boundaries with taxation. And some states, if you want to be able to obtain a license in order to collect sales and use taxes, you have to register as a foreign entity. So it's really important to look into the licensing requirements of any particular state, see if those require you to qualify, without going into the question of whether or not you're doing business. So that is something that definitely needs to be looked into. As for service of process, having a company register as a foreign corporation does aid this. It makes it much easier. You know who to serve process on and where they are, and this information must be kept current. However, if you're able to get general jurisdiction over a foreign corporation and comply with the rules for that state for serving process, you can still be hailed in the courts of that foreign jurisdiction. Generally, there's been a presumption that if you have registered as a foreign corporation, that you've consented to general jurisdiction within that state. Recently, over the past year, court cases have been trending against this, so that by merely qualifying as a foreign corporation within a state, it doesn't equate to consent to general jurisdiction. This kind of goes against the grain, but this is where case law is heading. So it's important to pay attention to what you're doing and pay attention to the fact that the transaction, like transacting business for general jurisdiction purposes, is different from doing business for qualification requirements. So there are a number of adverse consequences for failing to qualify as a foreign corporation. Generally, the Small Business Corporation Act, they have a number of penalties, and their primary goals are to encourage foreign corporations to qualify and to provide some method for states to collect reasonable non-punitive fees. Since the additional tax liability is a significant factor in a corporation's decision whether or not to qualify in a foreign state, it makes sense for states to include hefty monetary penalties for failure to comply with these qualification statutes. Generally, states are highly motivated to pursue foreign corporations that are non-compliant with their qualification statutes, primarily to discourage unfair competition with domestic companies, and the fact that pursuing these non-complying corporations results in a significant revenue stream to the state, more of an added bonus at that point. So the primary penalty under the Model Business Corporation Act is that you are closed out from availing yourself of the court systems of a particular state. So a state can prevent a company from bringing suit or proceedings in that state's courts unless and or until it qualifies. It's basically, the policy is the state can close the courts to that non-complying foreign company because it shouldn't benefit from that court system in enforcing its rights when it's violated state law and it's not paying its fair share. Under the Model Business Corporation Act, a foreign corporation may not maintain proceedings in any court of a particular state until it's registered to do business in the state. That until is pretty significant, and it can vary from state to state. The importance of the until is that there's a possibility of cure here. So let's say a company was not qualified to do business in a state, and they wish to enforce their contract rights, and they file litigation while they're unqualified. They would need to, in this particular statute, because it's until, would need to qualify as a foreign corporation within that state in order to continue those proceedings. Because the filing itself, initiating litigation, isn't necessarily prohibited under this, but maintaining it is. So it's a really important one. Some states have unless in lieu of until, and that can be seen as a bar on even filing. This would, in some instances, extend to counterclaims filed against a foreign corporation that is not qualified within the state as a defendant. The distinction between maintaining and defending is usually, in most states, they are aware of that distinction. So counterclaims you would be able to make in any litigation. However, you might not be able to obtain a judgment based on those counterclaims until you've actually registered to do business. And when you cure, that means that you have to make up for any revenue that you haven't been paying during that time period. All right, Pat, if you wouldn't mind taking over.
Thank you, Beth. Thank you very much. This is Pat Nolan from CSC, and what we're looking at here on the screen is a real-life example of a qualification project that I handled back in 2015. Looking at it now, I can't believe it's 6 years ago. But in any event, a Fortune 500 client of CSC's came to us, and for whatever reason, they had been doing business for 15 years, since 2000, but had not qualified. So what I show on the screen here are the two fees. The one they had to pay because they were 15 years late is the first fee, and the second one is what they would have paid had they timely qualified back in 2000. So right there, Illinois, 21,000 plus versus 1,800. Very expensive. You don't want to get in that situation too often. Illinois is fair, though, and we'll talk a little bit more about this in a later slide. But Illinois bases their fees on the proportion of your business and property in their state versus that business and property everywhere. So, for example, if you were doing $1 million throughout the country and only $100,000 in Illinois, the basis for your fee would be 1/10. So that's a positive. But as you can see, these fees can build up quickly, especially if you qualify after you've been doing business. Beth mentioned the little penalty there, and they're kind of delineated here in the next bullet points, so I'll kind of leave them out. Another state they had to qualify in was the state of Florida. And looking at that, the $70 fee in 2000 is still the same fee today in 2021. But because they had not qualified, they paid $1,920. Georgia, likewise, had they qualified timely, it was $225, ended up paying $825, and they say everything is big in the state of Texas, and their filing fees are too. I took the liberty of looking up their fee today. It's $750. 5 years ago, it was, 2000, I should say, was $600, and they ended up having to pay almost $10,000 because they were so late. Not every state asks the question, the date that you began doing business. These states clearly do. My own home state is a unique example. On the application for authority for corporations, the last question they ask you is to simply check a box. But those boxes read as follows. The foreign corporation has not, since its incorporation or since the date its authority to do business in New York was last surrendered, engaged in any activity in this state. That's box A. If you can't check that, the only other alternative is box B, which is the consent of the New York State Tax Commission is attached. Now, I know we have a large audience out there. I don't know how many folks practice in New York or have dealt with the New York State Tax Commission, but it is an arduous task and can take quite a long time. So if you have a rush qualification in New York and you've been doing business, you're probably looking at a minimum of 3 to 4 weeks before you can get the tax commission to issue that consent. So I think at this point, I'll turn it back over to Zach, and we'll go from there.
Thanks, Pat. And just to go back one slide for contract enforcement. So when you do cure in if the foreign corporation cures and qualifies as a foreign corporation within the state, all their actions and contracts within that state are retroactively permitted and valid. So some courts have looked at this to the point where they've extended this to invalidate some contracts. So if a foreign corporation did not qualify when it should have qualified in a state, and its contract party decides to void a contract, in some states that would be acceptable and approved by the court systems, regardless if whether or not the foreign corporation ends up curing and properly qualified. So that's something to look out for. Again, that's very state specific. Generally, once you cure, you get like valid, permissible action is given retroactive validation. So moving along, what's at stake? Personal liability. So before the model MBCA, some states actually held that corporate officers and directors that were acting on behalf of unqualified corporations were actually liable for the debts incurred by those corporations within that foreign state. Following the MBCA, courts conclude otherwise, thankfully, and that corporate officers are generally not liable for debts incurred by the unqualified corporations, or corporations whose authority has been revoked. I'm kind of lumping those into the same group here. They found that the penalties imposed by the Model Business Corporation Act were exclusive, so that is much better for everyone. So under the Model Business Corporations Act, any limitation of liability of a shareholder, director of a foreign corporation is not waived just because that foreign corporation is transacting business in that state without properly registering, or otherwise like not complying with qualification statutes. This is more of an extension of the general premise that a corporation is generally subject to the laws of the jurisdiction of its incorporation. So you'd have to look at the corporation or entity laws of the state of the incorporation to see whether or not those directors, members would be subject to personal liability. Beyond that, some states actually impose fines on individuals that act on behalf of these non-complying foreign corporations, unqualified foreign corporations. You can see the list there. And in some cases, these can actually be criminal offenses, which is terrifying to me personally. So again, you have to look at each state's statutes and each of these inquiries of whether or not a corporation is acting or doing business within a foreign state is very fact specific. So these are important ones to pay attention to. And then beyond this, so fees and penalties are not the only costs of failing to qualify. There are a number of them. There's significant, so the monetary fees and penalties. But in addition to that, there are consequences to the enforceability of its contracts, its ability to enforce or defend itself in lawsuits. There's also risk that corporate actions might be invalidated. Any licenses that they need to get might be conditioned on qualifications. So there's a number of consequences that should and can easily be avoided by qualifying when necessary.
Hey Beth, this is Zach. Could you go back? I'm gonna go back one. So I wanted to make one point. You mentioned it can create problems with reps and warranties, loan documents, etc. So I think, in your and I world, in the corporate and the finance lending world and such, I think it's important for businesses to understand that a lot of times what we see, and Beth and I probably draft this in every loan we work on, is a requirement or a rep and warranty that the business involved, the borrower, whoever, or even subsidiaries or any of these entities involved, are going to remain in good standing, and so and current on taxes and all these things. So what you have to be aware of is if you fall out of good favor with the state, that may trigger a default under loans, under your commercial contracts, under all kinds of other agreements you may not even think of. You may think, well, we're not really going to use this facility anymore. We're just going to kind of let it, fall off. But then what ends up happening is, your bank or your partner or somebody else, finds out that they're not in good standing, and that's a default under some arrangement, and now you have liability there too that you didn't even think about. And so, or maybe you did, but it didn't matter. So it's something just to be aware of, I think, especially in M&A and any kind of lending work, that your companies are staying in good standing, not violating any kind of events of default in your agreements, and just make sure that you're aware of those things when you operate or decide not to operate within a state. So that's all I wanted to add, Beth. Thank you.
Okay, folks, it's Pat again, and I think I'll speak to this slide a little bit. So we're doing business in the state. Now what do we do? Well, if you've already formed the entity, you already have your name. But it's surprising how many people don't realize that because they've, say, formed a company in Delaware or Nevada, and they got the name locked down there, each state is different. So the name would have to be available to qualify in that state. There's ways, to get around it if it's not, such as using a consent to use the name if the state accepts it, or qualifying under a fictitious name. The rest of the slides here is kind of particular to Illinois, but that's a good broad band of the questions that are asked on the applications. Another thing that I might add, well, Illinois is a little unique in that to qualify together with your application, you have to provide a certified copy of your certificate of incorporation and any amendments to it. But most states require a good standing certificate. They just don't want the application and the filing fee. They want to know that you're in good standing in the state that you were formed in. The other things frequently asked are, of course, the date that you incorporated, as well as the state, the registered agent name and address, names of officers and directors, and in Illinois, they want to know the total paid in capital. And as I mentioned earlier, that paid in capital is the basis for the filing fee. You take your property and business figures and whatever fraction you get from your property and business everywhere versus, property and business in Illinois versus everywhere, that's the fraction you use multiply times the paid in capital to arrive at the filing fee. My home state is a little unique in that they're one of the few that doesn't require a registered office. In New York, the Secretary of State is the agent for all business entities, and you just have to provide to the Secretary of State an address to which service process can be forwarded, and that can be anywhere in the United States. Pennsylvania, you don't really need a registered agent, but you do have to have a registered office within the state. And I think in all other states, there may be one or two more exceptions, you do have to have a registered agent in that state. At this point, I'll give it back to you, Zach or Beth.
Thanks, Pat. Just some kind of general considerations that that people should consider. So for lawyers, if you're issuing a legal opinion, you need to be aware of any consequences if you're opining as to whether an entity is qualified to do business. So something that you may want to say, kind of a drafting point, if you will, is maybe instead of saying that an entity is qualified, that you could schedule the jurisdictions for where it's qualified. So instead of saying the entity is qualified in every state it's required to be, well, is that true? Do you know that? I mean, so it kind of gets you in a trick bag where maybe that's true, but do you really know the law of all of these states that well to opine on that? And maybe you do, and that's great, and that's fine. But if you don't, you could redraft your opinion or your rep and warranty or however it's set up to say, here's a schedule of the entities where they are qualified. So you know for sure, and you're only speaking to those states because you scheduled it. Another consideration is licenses or permits that require qualification. For example, insurance and banking in most states, if not all states, require that you be qualified to operate within that state. And so, and on top of other things. So if you want to be an insurance broker or the foreign entity or whatever is going to be an insurance broker or a banker, you have to qualify in most states, and then you can get your insurance license, or, your broker license, your banking license, or whatever it is. And so those are considerations that have to be made when you're advising clients or when you decide to expand or any of that stuff. And so some of that is at a local level too. If you need to get local business permits, if you need to get a town permit or a county permit or something like that, you may be required by the town to do that. And so those are things you have to weigh and look at and whenever you're doing any kind of foreign registration. So another consideration is tax. I'm not a tax lawyer, so I have no idea, the nuances involved, but there's some very clear considerations that are made, and that is franchise tax, sales tax, income tax. Those are things that are obvious. If you're going to do business in a state, you need to know what the tax consequences are going to be, because you don't want to think it's something and then you get hit with a huge tax bill. And kind of to what Pat discussed earlier, is you don't want to think, well, I don't need to register, and then you get hit with a $30,000 franchise tax bill from Illinois because you didn't register in time, and you let it sit for a few years or whatever the case is. And then kind of also to a point Beth made is maybe you are gearing up for litigation, but you're barred from litigation because you have these back taxes, which now you have to pay to even litigate a claim, which maybe you're owed. And so you just have to understand kind of what the tax landscape is in each of these states that you're going to do business so you know what you're getting into. And then aside from that, the consequences of tax, you also should know what kind of compliance requirements there are, because some states require you to file annual tax reports or tax statements, or require you to maintain certain documents, in case of an audit or something like that. So it's also important to understand what those state-specific requirements are. But I think you kind of get a lot of that from either your tax attorneys or your accountants. That'll be a good place to get that information. So just kind of a general overview. It's really important that attorneys, business consultants, business owners, officers, agents, you have to be proactive in understanding the laws and the landscape of the state you're in and understanding your role in those states. So it goes back to the analysis of what is doing business, what is not doing business. You have to look at it in the totality of the situation. And so if you're doing a few things in a state that you think maybe not be business, it might be worth consulting an attorney in that state or someone experienced dealing with the type of business you're in or the state statutes involved, and that kind of thing, because you don't want to be reactive and now you have this huge bill, or now you can't operate out of this facility which you thought you were going to be able to, and you sunk all kind of capital into preparing it or something like that. So you have to be proactive. The facts are going to drive each of these cases, and it's going to vary not only case by case, but state by state, and it's going to change as the law develops too. So this isn't going to be, here we did this presentation today, and that'll be it, go forward, and don't think about it again. It's going to continue to change in each state based on your situation. So you always have to be looking at the facts involved. Another kind of important plug is vendors like CSC are good at compiling this information, pulling the resources together, and then advising people on how to deal with these filings, with the requirements of each state, and help guide people through. And we use CSC and we use other vendors for the same purpose, because sometimes you have a question and they have this information readily available, so it's a good resource to go to try to get some of that information. So you need to know the ins and outs of your business. You're going to know, the business owners, the attorneys, whoever's involved in the business are going to know more closely what the business is doing and how involved it is. And so if you have one employee who's working from home in another state, maybe that person's involvement in that other state and what contacts that has and how involved it's going to be with that person being in another state. But that's on the business owners, that's on the companies to know, so that they know how to comply if there are any requirements at all, with that one employee or that one facility or whatever the case may be. You need to consider the consequences of not registering, but maybe you should have. So are there tax consequences, penalties, litigation, et cetera, that are going to be connected to not registering? Are you going to foreclose certain things that you might have had available to you if you did register? And then the flip side of that, are there consequences to registering when maybe you shouldn't have or didn't need to? For example, if you registered because you were just trying to be proactive, you just want to make sure you covered your bases, but then in doing so, like in Philadelphia, if you register, it automatically you consent to general jurisdiction in court. So do you want to open yourself up to litigation in Pennsylvania if you didn't have to? And maybe you did have to. You know, that's where it gets into the case-by-case situation. Maybe you were already required to, it doesn't matter. But maybe you didn't. And so you need to consider both of those avenues to decide whether registration was proper.